Losing a loved one is undeniably one of the most difficult experiences any of us will ever face. The grief is overwhelming, and the emotional toll is incredibly heavy. But imagine navigating that profound sorrow while simultaneously facing a complicated maze of legal and financial uncertainties.
For many families, this added layer of stress becomes a harsh reality when a relative passes away without leaving a will. Suddenly, the unspoken questions become urgent legal matters. Who inherits the house? Who manages the bank accounts? And who makes the difficult decisions? Today, we are exploring exactly what happens when there is no will and how you can protect your family from these unintended consequences.
Losing a loved one is undeniably one of the most painful experiences in life, but that grief is exponentially multiplied when the family discovers there is no will. Imagine sitting at the kitchen table, already emotionally exhausted, staring at a disorganized mountain of bills, bank statements, and old photographs, trying to piece together a financial puzzle without the picture on the box. This overwhelming burden is exactly what happens when someone dies without a legally binding will. In the legal world, passing away without a valid will is known as dying intestate. What does intestacy actually mean for the people left behind? Simply put, the deceased left no official instructions on how to distribute assets, handle debts, or care for minor children. Instead of clear directives, the surviving family members are met with a giant, stressful question mark.
Because there is no written roadmap, the state steps in to make these deeply personal decisions for you. Your local government will rely on default intestacy laws to determine who gets what, and their rigid formula rarely aligns with what you or your family would have actually wanted. This practical chaos forces your grieving relatives to spend months navigating a cold legal system, draining both their emotional energy and the estate's financial resources. What happens when someone passes away without leaving a will? In the legal world, this is known as dying intestate. When you do not make these crucial decisions for yourself, the state you live in steps in to make them for you. It is a one-size-fits-all approach that completely ignores your unique personal life, leaving your legacy in the hands of the government. Because intestacy laws are governed at the state level, there is no single rule that applies to everyone across the country. What happens to your assets in California might be drastically different from what happens in Texas or New York. A court-appointed administrator will distribute your belongings strictly according to state statutes, completely ignoring any verbal promises you might have made to loved ones. So, who actually gets your money and property? The state uses what is called a line of succession, acting like a rigid ladder of inheritance. At the very top is usually your surviving spouse. If you have children, assets are typically split between them. If you do not have a spouse or children, the state looks up the ladder to your parents, then moves to siblings and eventually to distant relatives. This rigid hierarchy does not account for modern family dynamics. Unmarried partners receive absolutely nothing. Close friends and favorite charities are entirely left out. Instead, an estranged relative you haven't spoken to in decades could end up inheriting everything. Relying on intestacy laws leaves your life's work to a cold, indifferent legal formula. What actually happens to your assets when you die without a will? Enter the state's default rulebook, known legally as intestate succession. Think of it as a pre-written will that you never signed, based entirely on your family tree. The most common inheritance scenario involves a surviving spouse and children. You might assume everything automatically goes to your husband or wife, but the reality is much more complicated. Intestacy laws vary wildly from state to state. Let us look at a side-by-side comparison. In State A, a surviving spouse might inherit 100% of your assets. However, in State B, your spouse might only receive 50%. What if you pass away without a spouse or children? The line of succession simply moves up and out. Your assets typically go to your parents first. If your parents are no longer living, the estate is divided among your siblings, or even nieces and nephews. But here is the biggest danger of relying on the state's formula. Intestacy laws strictly recognize legal marriages and blood relations. This means unmarried partners, close friends, or stepchildren you never legally adopted will receive absolutely nothing. no matter how long they were a crucial part of your life. The state decides your family's future, without considering your actual relationships. When a person passes away without a will, the state steps in to manage the estate. Since you didn't name an executor, the probate court will appoint an administrator, sometimes called a personal representative, to handle your affairs. This appointed individual takes on a massive responsibility. Their duties follow a strict legal process. First, they must track down and meticulously identify all of your assets. Next, they are responsible for notifying creditors and paying off any outstanding debts or taxes using estate funds. Only after these rigorous steps are completed can they finally distribute the remaining assets to your legal heirs. But navigating probate without a will is rarely a smooth ride. The court's mandatory involvement at almost every step means the process can drag on for months or even years. Alongside these significant time delays, your estate will likely face increased legal costs and administrative fees, steadily shrinking the inheritance your loved ones will ultimately receive. Without your clear instructions to guide them, the administrator is bound by rigid state laws, leaving no room for your personal wishes. But it certainly does not have to end this way. By taking the simple, proactive step of creating a legally valid will, you take back complete control of your legacy. You provide absolute clarity for the people you care about most, ensuring that your life's work is distributed exactly as you intend, without any guesswork or confusion. Most importantly, a thoughtfully drafted will dramatically reduces the emotional and financial stress on your family during an already difficult time of grief. Instead of leaving behind a complex, frustrating puzzle for them to solve in the courts, you leave behind a clear, comforting roadmap that guides them through the process. Do not leave your family's future to chance, and never let state laws decide what happens to your lifetime of hard work. Take the essential steps today to protect your loved ones, preserve your legacy, and secure your own peace of mind. Thank you so much for watching. We covered a lot today, from the confusing rules of intestacy to the unexpected family conflicts that can arise without a will. The biggest takeaway is that proper estate planning brings invaluable peace of mind. It ensures your wishes are honored and your loved ones are protected from unnecessary stress. Taking the first step to secure your legacy is easier than you might think. If you found this video helpful, please give it a thumbs up and subscribe to our channel for more insights. Have a question or an experience to share? Leave a comment below. We would love to hear from you. Do not leave your legacy to chance. Start planning today and give your family the gift of certainty. Until next time, take care.